evening and welcome. My name is Carolyn Evans. I'm the Dean of the Melbourne Law School, and on behalf of my colleague, Professor Adrienne Stone, Director of the Centre for Comparative Constitutional Studies, and indeed all of my colleagues and our students, it's my great pleasure to welcome you here this evening for the lecture on constitutional reform by the Honourable Nicola Roxon, Attorney-General of Australia. This address also marks the commencement of our conference on recent developments in constitutional law, and can I issue a particularly warm welcome for those of you who've come for that conference, including those who've travelled, I know, quite a long way to be here. I begin by acknowledging that we meet on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders, past and present. Well, tonight I have the very pleasant task of introducing the Commonwealth Attorney-General, the Honourable Nicola Roxon. The Attorney-General, as we never stop telling people, graduated from this law school and this university with degrees in arts and law, scoring top marks in law so that she was the Supreme Court Prize winner for that year. Many of our current teachers remember her as fiercely intellectual, a formidable personality, and none appear in the least bit surprised that she's gone on to achieve so much in her career. Prior to entering Parliament, the Attorney-General worked as Associate for Justice Gaudron, then of the High Court, as a lawyer at Maurice Blackburn and as an organiser at the National Union of Workers. However, it is in her time since she entered Parliament as member for Gellibrand that she's become best known. She held many shadow portfolios before the ALP was elected to government. Since that time, and before becoming Attorney-General, she was, of course, Federal Minister for Health and Ageing, where she oversaw major reforms to Australia's public hospital, primary care and preventative health systems. It's particularly worth noting that in her roles, both her roles as Attorney-General and as Minister for Health, she's played a really significant role in the move to greater regulation of tobacco, particularly through the plain packaging laws. And if I could perhaps make a quick side note, a number of colleagues here at the Law School have also been engaged in that important area of public policy development, lending their expertise in areas of constitutional law, intellectual property and world trade, both individually and through our collaboration with the Cancer Council. Last year, the Attorney-General was recognised with the World Health Organisation Award and World Health Organisation Director-General's Special Certificate for her achievements. It was said in the citation that it recognises Minister Roxon's unwavering leadership in the field of health and describes the proposal to introduce plain packaging as a bold and breakthrough approach. Her actions, it said, have inspired political leaders in many, many other countries to take strong, calibrated and decisive action. It is, of course, not on that topic that she's here to talk to us tonight, but another very important issue, that of constitutional reform in Australia. And as a constitutional lawyer myself, I must admit to having some interest in hearing what we will be about to hear from the Attorney tonight. We're delighted that an alumna of ours who's made such an important impact nationally and internationally can be with us here tonight to discuss this important topic. The Attorney will present her paper and then she's kindly agreed to take some questions afterwards. They will be chaired by my colleague, Professor Stone, and could I take this opportunity to acknowledge Professor Stone's leadership in organising tonight's event and also the conference that will follow it. Could you please note that both the lecture and the question time will be recorded. It's now my great pleasure to call on the Attorney-General, the Honourable Nicola Roxon, to deliver her lecture on constitutional reform.
Thank you very much for that kind introduction, Carolyn. I'm very happy for you to tell the world that I'm a student of Melbourne Uni. I've always been very proud that I got such a good education here, and I suspect many of the country's lawyers are now pleased I indeed did get that good education. Can I also acknowledge the traditional owners of the land that we're meeting on and pay my respects to their elders, both past and present? Can I acknowledge the Dean, Carolyn, who's just made that introduction, and note, having just sat briefly in her office, that I walked past the wall of fame of those deans that preceded her, and there is something that is quite different about your current dean. And Carolyn, I'm pleased that we have now the first female dean of Melbourne University, and I'm of course very proud to be the first female Attorney-General of the Commonwealth. I did note there, and I understand that he's with us in the audience, that the Dean of the time when I was a student, Michael Cromlin, is here, and I know that there are very many other past and present members of the judiciary leading professors, of course, of the law school, I need to be biased and mention two good friends of mine who are both associates at the same time as me at the High Court, being Professor Adrienne Stone and Simon Evans. I am very pleased, Adrienne and Simon, that the Superior Law School has lured you both from the north, and I'm sure that the students of Melbourne Uni are very pleased too. It is nice to come back to your own university to provide a lecture like this, and particularly to speak as part of the conference that's kicking off tomorrow. I would like to tell you that as a student at this law school 20 years ago, that I always knew that I would be back here as the Attorney General. But in truth, despite those kind words that Carolyn says my previous lecturers might have passed, I can tell you no such thing at all. I am very pleased, though, with the quality of the education. I do rather wish that I might have kept a few more of my notes because, of course, that education is being called upon in lots and lots of different ways. I do seem to run into the Melbourne University diaspora all over the place now. Sally Walker has just become Secretary-General of the Law Council. Greg Craven seems to be in the papers even more than I am. Hilary Charlesworth was recently addressing a meeting of attorneys. Fred Ellinghouse, still with you here, and Ted Wright have been lobbying for contract law reforms. And there are no small number of past students who are in the courts often, I might say usually taking the Commonwealth to the High Court for something or other. And I have to admit that there are occasions when I wish Melbourne University didn't educate those people quite so well. They do seem to have a fairly good record against the Commonwealth before the court. Given I'm here at a constitutional conference, particularly, I know that there are also a broader selection in the audience, but for those academics who are attending the conference, I suppose there's nothing that they love more than complex High Court decisions, and will delight tomorrow in making predictions of the future. But I thought that the value that I might be able to add in a speech like this as the Attorney General and as a politician is to provide a different sort of practical perspective on the issues that we face, and to talk a little bit about how modern government runs, the way the Constitution and the court have an impact on what we do each and every day. Since Federation, of course, constitutional law has been built on a battle of ideas, disputes between levels of government and the inherent tensions that there are between arms of government. Constitutional reform has been affected not just by the direct changes to the text of the Constitution via referendum, but also through changing interpretations, fiscal power, approaches to government, taxation revenue sources, political realities and community expectations. And our constitutional arrangements have undeniably evolved since the Constitution was first drafted, and there have been many changes over the 100 years. And the evolution has gone well beyond the 8 successful referendums which have amended the actual text of the Constitution. Of course, this number may increase to 10 through the proposals currently before the community to recognise Indigenous Australians and local government in the Constitution. And I do hope in my lifetime that we will also see a change to a republic. Beyond this, though, our Constitution is and should be seen as a living document. Without incremental and evolutionary change, often only arising from individuals challenging specific laws, but also from the evolving responsibilities of arms and levels of government, we would have a document that was fundamentally separated from the modern world. And deluding ourselves that we might at some point clarify those remaining issues in the Constitution and fix it forever in time could jeopardise the flexibility that the nation needs to respond to new social and economic circumstances. And which is why I titled my speech with a question really, a static constitution, a very Australian standoff, because the document that governs our democracy can only strictly be changed by amending the text with a strong public vote driven by clear consensus among political groups. Nonetheless, the meaning and reach of the Constitution in fact changes and evolves each and every year, driven by case law, challenges and battles over the very scope of government in Australia. So I want to talk about the role of the High Court in interpreting the Constitution and the role of the Parliament and the Executive in responding to High Court rulings, in particular using the most contemporary example of the Williams case and its implications for programs well beyond the chaplain's program that was at issue. But before we get to that, as you would be well aware in this audience, constitutional change in Australia is very rare, with only 8 successful amendments in 44 attempts over more than 100 years. And despite the actual rarity of constitutional change, it can be tempting in the face of challenging High Court decisions or a heated stoush between Commonwealth and state governments to wonder whether components of the Constitution itself might be the problem, and so changing the text of the Constitution is the solution. Again, as this audience would well know, Section 128 of the Constitution sets a deliberately high bar for constitutional change by requiring a majority of total votes cast to be yes votes and a majority of votes cast in the majority of states to be yes votes. Despite the hurdles, the Labor Party, from the time of Federation, the party of reform and progress, has shown itself willing to challenge the constitutional status quo more than all the other parties in Australia's history. Our 25 attempts stand against 9 of the Liberal and National governments and the 10 of governments no longer in the political spectrum, including the protectionist and fusion coalitions. So Labor governments have been prepared to push for change, but history also tells us of the fairly poor success rate. So we can't ignore that history. Whatever the constitutional issue, we must always approach major reform proposals with our eyes open to the degree of difficulty and its implications. Constitutional reform requires a very significant investment, whether it's taxpayer funds, the attention and effort of the community, the Parliament and the Executive are all required. And it of course should not be forgotten that this always takes place in a very congested sphere of important public policy issues, media debate and increasingly busy and pressured family lives. So constitutional reform is a high-stakes contest with a poor success rate. The potential benefits need to be carefully weighed against the certain costs. And this doesn't mean for a moment that we should never attempt reform. After all, the government is progressing constitutional change on 2 fronts as we speak. But those who advocate for reform should also carefully consider the task ahead of them too, and not imagine that this is a challenge just for government. By many measures, the most successful referendum was the 1967 referendum to remove Section 127 of the Constitution, which provided that so-called Aboriginal natives were not to be counted in determining the population of the Commonwealth, and to remove the bar on the Commonwealth legislating with respect to the Aboriginal race in any state and in reliance on subsection 5126. And I've noticed Catherine Branson in the audience here as the President of the Human Rights Commission for a couple more weeks. I know that these sorts of issues would be close to her heart, and let me take the chance, having recognised Catherine here, I'm sorry I didn't know you were here earlier, to thank her for the work that she's done over a very difficult time. It's never an easy job to head a Human Rights Commission, and you should be proud of what you've done. It's interesting and telling, I think, that 1967 referendum was the most decisive since Federation. More than 90% of voters voted in favour of the changes. The 1967 referendum was the high point for constitutional reform, but it also provides, I think, some lessons for constitutional reformers. And that is, of course, that the biggest challenge for constitutional change is to make that change meaningful for those who matter most, and that is the Australian voting public. For without widespread public support, we all know that constitutional reform will fail. And achieving this support is by no means an easy task. History again shows us that our political opponents have been expert at opposing referendum and expert at harnessing large no votes. Don't think of Mr Abbott just on the Republic, but he and Mr Reith in 1988 on local government, parliamentary terms, the expansion of the right of trial by jury, a more just electoral process, to name just a few. In my eyes, these are quite ugly examples that prove a pretty simple point. No matter what the innate merits of a proposal, referendums fail without bipartisan support. In fact, people will probably remember Mr Abbott's campaign slogan, "Don't trust the politicians," used to damn the Republic referendum. But it not just condemned the Republic to failure, it also trashed his and my profession in the process, and probably also damaged the chances of future referendums on other issues proposed by government or the Parliament. Malcolm Turnbull said at the time that it broke the country's heart. I think he might have done even more damage to the hearts and minds of constitutional reformers. Even with bipartisan support, the voting public must be invigorated to support change. reformers need to build the momentum and passion in voters to avoid the inevitable don't know, vote no movement. This is important because it means that politicians have to be active, it means that we have to be united, but it also means that that isn't enough. Civil society must be engaged and lead too, and it takes dozens of politicians to do what one school principal, one columnist, one sports star, dare I say one vice-chancellor or dean can do if they put their voice to a particular cause. And frankly, we haven't seen yet much of that leadership and engagement from the broader community on the two proposals currently before the government and the people. So this challenge awaits constitutional reformers on two fronts. That's the reform of the Constitution to recognise Indigenous Australians and also reforms to recognise local government. We've already seen efforts in both these areas to amend the Constitution fail before, so it raises the stakes, I think, even higher this time round. It's a question that, whatever its final form, particularly in respect of recognising Indigenous Australians, that frankly I think is too important to fail. So we do have to make sure that the politics does not drive this debate, that political, community and Indigenous leaders work together to build community consensus. And to help with this process, the government asked a group of eminent Australians to provide advice to us and the community as to the best way to ensure Indigenous recognition proposals that the proposal received the prominence that it deserves and that the community has access to information that they need to make an informed decision. The expert panel's report provided a proposal to make a number of amendments to the Constitution, including repealing certain sections and inserting new sections 55A, 116A, 127A. This would provide a power to make laws for Aboriginal and Torres Strait Islander peoples, to prohibit racial discrimination and to recognise Aboriginal and Torres Strait Islander languages as well as English. The panel also recommended a process for the proposed referendum, as well as a list of factors that must be considered in assessing whether a referendum will succeed and therefore whether a referendum should proceed. I understand that Professor Toomey will speak at this conference tomorrow on the flaws of the proposal put forward by the panel, which is fine. Of course, we need this level of engagement and criticism to help shape the final question to the people. But I did want to make the point that there's no point us getting the technical detail right without putting attention into winning the hearts and minds to the cause for change. Our panel recommended and the government accepted that the need for a properly resourced public education and awareness program and has committed $10 million to continue to build public awareness and community support for constitutional recognition of Indigenous Australians. This work is being led by Reconciliation Australia, supported by a reference group of business and community groups, the Australian Human Rights Commission and the National Congress of Australia's First Peoples and members of the expert panel. It also urged active consultation and support from the opposition, the Greens, independent members and state and territory governments before making a decision to proceed. It's fair to say that this part is not going so well, despite our attempts. It is a shame, I think, that there is some DNA in the Liberal Party that has not been shaken and that negativity has kicked in again. Senator Brandis, in fact, has said and made, I think, an active choice to play party politics at this pivotal moment, that he supports the referendum but it shouldn't proceed under the current Prime Minister. I've been struggling with how that exactly works. Of course, I don't agree that we should have this serious issue brought into the partisan daily politics. It will hardly help ensure its success. But I don't understand, if you would support this proposal with another Prime Minister, what possible logic there is of saying no now, other than possibly spite. And I think it's hardly edifying. If people do want this reform to work, a referendum to be put and to succeed, then we do have to find some way to come together, to work together. And I've been heartened to hear the words of people like Ken Wyatt, a Liberal MP, our first Indigenous MP in the House of Representatives, who strongly supported Indigenous recognition in the past. The government's also made a commitment to pursue a referendum for the recognition of local government in the Constitution. It's of note that both past attempts in 1988 and 1974 to recognise local government have been unsuccessful. And while the government has made this commitment, my colleague Simon Crean, who is the Minister for Local Government, stated recently that given this history, it's clear that we need to be confident that support will come from a broad base of the community. There's a very real prospect, again, that if we proceed and lose, that would be the final death knell for local government recognition within the Constitution. Future governments will just not waste the time and effort on a fourth attempt. The expert panel was chaired by Jim Spiegelman, the former Chief Justice of the New South Wales Supreme Court, and it did identify uncertainty around financial payments directly to local councils as a key factor for supporting the case for recognising local government in the Constitution. And local governments themselves have been very keen supporters. Again, it's true to say that the states have been a little less enthusiastic. I think it might be an interesting test of the community's engagement with our different levels of government if such a referendum were to be put forward with bipartisan support at the Commonwealth level and opposition at the state level, although I suspect I might be getting ahead of myself there. The recent High Court judgment in the Williams case certainly adds a layer of constitutional context to that question. The decision did not, as some had predicted, rule out the possibility of government spending directed to local government bodies, but it has perhaps given some extra weight to the arguments for change. Leaving aside the explicit changes to the Constitution through referendum, let's also turn to the way constitutional arrangements evolve, or at least adapt, over time. Some changes occur in practice, such as the referral of the corporation's power, and are not challenged at all. They're accepted by government players as they're agreed, or they suit all interests. Others occur incrementally. For example, the postal and telegraphic power provided for by subsection 51(5) of the Constitution, for example, has been construed as a power over many forms of modern electronic communication, while others occur gradually over time, such as the Commonwealth's expanding tax base and resulting fiscal power in relation to the states. And of course, the opportunity to challenge laws with the consequent possibility of developing constitutional interpretation has expanded as the amount of legislation brought forward in an increasingly complex society has expanded. From the 232 total number of acts in 1910, we jumped to 2,500 in 1950 to 11,717 at the end of 2011. So governments of all persuasions have sought to regulate and respond to an increasingly complex Australian society. The opportunity has expanded in that there are more laws a person might challenge, but in the vast majority of cases, there is not an agitated or cashed-up litigant to test each and every interesting question or borderline exercise of power. I think this is important in the context of the Williams decision. This case was brought in protest about a religious presence in a state school. According to all of the public and media reports, what motivated, indeed incensed Mr Williams was what he saw as an encroachment of church into state matters. Ironically, the only thing upon which all the High Court judges agreed was to reject this particular argument. But in bringing the challenge, Mr Williams has instigated a fundamental change to the way governments must set up programs that involve expenditure. In the event, many of you will be familiar with this, of course, the High Court judgment invalidated an agreement made by the Commonwealth under the National School Chaplaincy Program by a majority of 6-1. But you might also be aware that the majority itself was split, with some judgments suggesting a greater prospect that the court may in the future find that Commonwealth spending must be tied to a particular head of legislative power. However, despite the commentary signalling this as a definite direction of the future, or even a consequence of the decision, this was just a flag by some judges, and the case did not decide this matter. As an aside, however, I might tell you that these sorts of ruminations are the ones that present the odd headache for governments in planning sensibly and carefully for the future. Such a split, even amongst the majority, made the decision more difficult for government lawyers in the immediate aftermath, but I anticipate that it will prove a boon for PhD students over coming years. As it does for all major impending decisions, the government had conducted extensive contingency planning for a wide range of possible outcomes in this case, and the importance of the government's contingency planning was immediately clear. The Williams decision overturned the understanding on which the Commonwealth had acted since Federation, that the Commonwealth could develop and administer spending programs without the need for legislative authority for these programs. In Williams, a majority of the High Court held that legislative authority is necessary for certain spending. So the Williams case has significant implications for the validity of forms of Commonwealth spending programs or national reforms initiatives that haven't traditionally been supported by legislation other than an Appropriation Act. From the most recent Commonwealth initiatives, such as the establishment of the National Mental Health Commission to drive system improvements for the benefits of millions of Australians living with mental health difficulties, to long-running programs such as veterans' commemorative activities and the maintenance of war graves. The Court was clear that not all spending is affected, such as the ordinary services of government and arrangements with states. But thanks to our preparation, the government was able to respond swiftly to the Williams decision and enacted legislation within 8 days of the judgment to ensure that legislative authority was put in place for hundreds of potentially affected programs. This involved extensive meetings by myself and my office with parliamentarians from across the political spectrum, drafting in shifts by the Office of Parliamentary Counsel in consultation with the Attorney-General's Department, the Acting Solicitor-General, coordination by the Finance Department regarding affected programs across all agencies, to complete an administrative and legislative process in just over a week, a process that in many circumstances would take 12 months or often much more. So I do ask, who says the Parliament is hopelessly deadlocked? I thought that was quite impressive, really. I like to think of the result as being extraordinarily efficient or sensibly pragmatic, but I have to tell you I think it was a bit lucky too. Had Parliament not been sitting for an extended time, what would the public officials spending money on these other programs actually have done? Community and building programs may have ground to a halt, people could have been unpaid, and I think these consequences were a long way from Mr Williams' concerns about his children's secular education. But this is only the most recent case in a long history of cases fought on one issue and having extensive consequences for others. Aside from pointing to the need generally for governments to adopt a prudent approach in preparation for potential challenges, this judgment and the rapid response graphically illustrates the breadth and impact of constitutional interpretation by the High Court and the Parliament's role as society's elected representatives in responding to decisions. As I said, I think this decision is fertile ground for in-depth analysis and will support many a thesis in the future. But my brief contribution today is really to note that on occasions where a judgment goes to the core of constitutional questions, particularly regarding the operation of the executive government, it may be necessary for governments to put forward legislation for the consideration of Parliament to address the judgment. In this case, the Court made clear that the constitutional flaw was the lack of express parliamentary approval for spending on this program. The cure to this newly identified flaw was to pass such legislation for this program and for the many others arguably in an equivalent position. And I want to emphasise here my strong view that this exercise is neither an affront to the Court's decision nor the Parliament stepping beyond its bounds. In fact, in my view, it gives great deference to the Court in acting immediately to address the concerns raised by it. The Commonwealth and Executive and the Parliament have a responsibility to exercise judgment and react quickly following important decisions that have broad consequences. Where necessary and possible, they should act to ensure the government continues to operate within constitutional guidelines that have been provided by the Court. And this is simply the natural dynamic of interaction between the Executive, the Parliament and the Judiciary. The Williams decision was not the first occasion on which a government has needed to respond swiftly to a significant High Court decision, which has challenged the government's understanding of the Constitution's requirements, and it won't be the last. It's simply the most recent demonstration that the meaning of the Constitution is a matter that can never be taken to be settled, no matter how long the Executive of the day may have wished it so. The Act passed following the Williams decision addressed the new requirement identified by the High Court, as I mentioned, that there must be supporting legislation for programs, and provides now a legislative basis for over 400 existing programs, some of which have been running for many years. These programs comprised a significant portion of government expenditure. And to just give you a couple of other examples to add to those that I'd flagged, they supported things like eligible primary producers and small businesses, with free financial counselling to manage adjustment pressures and remain viable. In this financial year, that costs around $15 million, a focus particularly for rural services. Programs conducted in my portfolio under the auspices of the National Counter-Terrorism Committee that support the coordination of nationwide counter-terrorism capability through actions including the delivery of training, the conduct of exercise activities and the purchase of specialist equipment. I really just flag those because I didn't think you'd want the list of 400, but really to give you the sense of the range and breadth of programs that were affected by this decision. Of course, also to recognise that constitutional interpretation is undertaken by the High Court is integral to the meaning of the Constitution, is by extension, of course, recognising the very important role of the individual judges within the framework of the Constitution and common law as it's developed in Australia. And I notice that we have the Honourable Justice Dawson here as well, one of the judges on the High Court when I was lucky enough to be an associate. Of course, from its inception, there have been allegations that High Court appointments have been made by governments in the hope that future decisions will trend towards their general view of the world. And more than once, this undercurrent has become overt, particularly in attempts to address perceived judicial activism. I think it's a testament to the strength of the court, and maybe to human nature, that so many governments have been left disappointed by their appointees' subsequent decisions. I need only mention William Dean, appointed by the coalition government, perhaps hoping his quiet, modest and religious nature indicated a conservative. But as Justice Kirby stated in reflecting on the appointment of William Dean, and also I think Chief Justice Mason, the appointing governments probably expected, in Justice Kirby's word, capital C conservatives. In fact, the C ought to have stood for creative. Justice Dean turned out to be one of the most creative and progressive thinkers on the court, and as you would be aware, with Justice Gaudron, co-authored the famous judgment in the Mabo No. 2 case. Of course, Justice Dean was then made Governor-General by Prime Minister Keating, just to highlight how perceptions can change. I make these general comments, of course, in the shadow of 2 upcoming vacancies to the court, and to assure people that our key consideration will be to identify the best legal brains in the country. For all the speculation, I am not naive enough to think that looking for anything other than brilliant lawyers would be wise, or indeed effective. I have asked for and received many nominations from diverse areas of practice across the country and with different experience, and it's given the government a wonderful pool of candidates to consider. And given that Justice Gummow retires in October, we'll be soon making an announcement about his replacement. That's not a scoop I'm making today, however, at this conference. So just to conclude, despite the rigidity of Australia's constitutional arrangements from a textual perspective, it can't be doubted that those arrangements are resilient or that they remain adaptable to broad-based developments in Australian society. Cases like the Williams case remind us that it can never, and never should be, thought of as a settled, final and beyond new interpretations. While this inevitably creates problems for governments of the day, this evolution is also what allows us to keep the Constitution relevant and responsive to Australian society. And we must remember that it's governments and government practices that change too, often inviting new approaches to be tested in the courts. So even if constitutional reform is defined strictly as constitutional amendment, there have been important successes. But the reality is that constitutional reform in this strict sense can only be achieved where there is broad community support for constitutional change. The government believes the time has come for changes to reflect the important place of Indigenous Australians in our society and the significant role of local government. However, the Constitution leaves no doubt about one issue, and that is who is responsible for changing Australia's fundamental legal document. And it isn't the government, and it isn't the court. It's only the Australian people voting at a referendum who can bring about such a change, and it will be very interesting to see if they do so. Thank you.
Well, good evening. I'm Adrienne Stone. I'm the Director of the Centre for Comparative Constitutional Studies. The Attorney-General has very graciously agreed to take some questions, and so I will be facilitating a moment of question time. If you would like to ask a question, please do identify yourself, and there is a roving microphone which will be carried to you, and I would ask simply that when you ask your question that you be both succinct and also to identify yourself. So let me throw the floor open for questions. There's one, Eva, just down here on the end.
Hi, my name's Jane. I'm actually a reporter at The Age. You mentioned Professor Anne Toomey earlier. I actually spoke to her recently with regards to a story about the amendment to the financial framework legislation, and she and many other constitutional law professors were quite critical of the amendment that allowed you to continue funding 427 programs on the basis that it allows governments to pork barrel rather than requiring proper scrutiny of each individual grant and program, and therefore was not in the spirit of the High Court ruling, which required legislation to be drafted. What is your response to this criticism?
Well, I think it's wrong, but I think it's in the realm of constitutional lawyers to want to be able to debate these things. A requirement to have legislation is met by passing legislation. I don't think that there is an argument about that. There might be an argument, as we well know and can expect, that people might challenge components of that and might say that's not sufficient in a particular area. I do think you've got to ask the opposite question, and no doubt the court at some time will be asked to consider this too. There's, taken to its absolute extreme, are we really saying that every grant, you know, I'm announcing tomorrow 29 community grants that are going to communities who are working to counter extremism. Is anyone suggesting that each one of those grants should have a piece of legislation for it, or even that that one program should have a piece of legislation for it that has to be a standalone piece of legislation, that has to have 4 committee inquiries, that has to be before the Parliament for 10 months? It's not, I think, realistic for the way government runs to expect that you'll have a separate piece of legislation for each and every program. I think if you do want to go down that path, that probably what will end up then happening is governments will pass much broader pieces of legislation. You'll end up with a generic counter-terrorism piece of legislation, or community grant program legislation, or education expenditure that will be so general that and can be dealt with in any sort of slow and deliberative way, that people would not be able to say there was not a piece of legislation, but it wouldn't really give the Parliament necessarily more oversight. And so I think we just have to question what it is that we want governments to do. I mean, it's especially not so much an issue in the Attorney-General's portfolio, but, for example, in the health portfolio, every single person that I ever met in the 4.5 years that I was the Health Minister had a particular thing that they wanted me to fund, most of which we had no legislative base to do, and when we often said yes. And I think that we have to find a way to match what it is that the community wants us to do. Sometimes we can rightly say no. Other times we absolutely all want to say yes. When I say we, I mean we as a community. So I think there is a real practical issue that is a little bit naive to say there should be a separate piece of legislation for every individual program that ever exists. But I can understand and don't think that there isn't room for argument about how much detail should be before the Parliament on particular programs. And of course the questions that get left open by the court that no doubt will be tested in the future about what level of relationship there needs to be with a head of power, etc. But you know, they ultimately were not dealt with to any finality in the Williams decision.
Gentleman in the centre here.
Hi, my name's Scott Fitzpatrick. I'm a student at the law school. I was just following up on your answer to that question. Would you not think it's more appropriate with the way that the Constitution has been designed that rather than the federal government creating individual pieces of legislation for all these grants, that it was more appropriate that the money be given to states, which were intended to actually be service deliverers under our constitutional design?
Well, I think there's two parts to that question. One part might be, should this be something the states are doing? That question could be asked, and you could ultimately, I think, go to a position where there was a fundamental redistribution of who does what, looking at the current way governments work, maybe realigning it more traditionally to what was perhaps envisaged when the Constitution was written. Whether it means then the Commonwealth should pay for it, I think, is a separate question. And it's, I think, an interesting example. The Williams case was not a case brought by the states who said, we don't want you to fund chaplains in our state schools. The states actually all said, great, we want other people who can provide counselling and support and social welfare and a whole range of other things. It was brought by a person, and I'm not disparaging his interest, with very clear particular view about his objection to that program. But I think it's interesting, if it was just a fight about who should be doing it, you would expect that state actors would actually be the ones bringing the case, and in this instance they weren't. Some of them did intervene, and some of them did intervene and then support Mr Williams in his argument, but I think it doesn't necessarily follow that that's then what would happen with the money, which I think is the great constitutional issue, really, the practical issue of which level of government can raise the money and which level of government should spend it. It's not, I think, practical or sustainable to think that one level will raise it all and you would give away to someone else the ability to spend it all.
John Pike, excuse me, John Pike from QUT Law School. Completely different topic. I mean, I must say the questions raised by the two previous questioners had been churning through my mind. I just want to rather gently take issue with you on the statement that the drafters of the Constitution deliberately set the bar high for constitutional reform. They quite clearly thought that they had created a flexible constitution, which was going to be much easier to amend than the US Constitution, which has to go through the terrible process of getting ratification by 2/3 of the states. I wonder why it went wrong. I suppose partly because party politics has become much more viciously contested since about 1910, when party politics became class-based rather than...
I'm glad it's not too recent then.
No, I don't think the recent dogfighting is anything terribly new. But I'd also like to suggest that I think some of the campaigning for the Yes case has been rather pathetic. And in particular, some of the campaigning for Yes cases by Labor Party proponents of constitutional change. I've lived through quite a lot of constitutional referendums in my life, being an old greybeard who dies it. It seems to me that repeatedly the ALP puts up a proposal which they think is fair and reasonable and will be accepted by everybody. They don't anticipate the venom of the no case, and they're not prepared for the venom of the no case. And it's almost as if the authors of the no case have been to a school of rhetoric, and the authors of the yes case are just trying to keep the rhetorical temperature as low as possible, doing nothing to counter the no arguments at all.
Okay, well, I'll take that as a question, because I can see people starting to put their hands up.
Can I add one more sentence? And basically crawling away into a cave the minute the no case starts to get vociferous.
Well, I think that there are some fair points in there, perhaps not put exactly the way I would put them, but I think it does confirm two things. Perhaps I wasn't making the link quite clear enough. I think it shows that as Labor governments, we've been prepared to be bold. We've been prepared to say, look, this is something that needs change and we'll argue for it. Now, maybe sometimes they haven't been argued as persuasively as people might have liked. But I think also there hasn't always been, often that's been done at the urging of strong advocates in the community who have pushed governments to act but have not been able to engage the community. And I guess my point is just governments are hugely influential in lots of things. We're actually not spectacularly influential in convincing people they should change the constitution. Actually, other players are often more influential and more trusted. And so I guess my point that I was trying to make there is not that we always get it right. We have obviously not always got it right when you look at the history, but that we've also learnt that the community engagement has to be at a different level. So I guess it reveals a little bit of frustration on government's part, or on our government's part, or on the Labor Party's part, that you're often urged to act without people being prepared to actually also work to develop that community support to make referendums successful. Of course, it's a bit chicken and egg. If you don't have leadership from government that the question is going to actually be put, then people don't always want to really get behind a campaign. But knowing whether a campaign is ready to be put or not can be a bit difficult. And I think we don't really want to be in a position on either of the two that are currently being considered that they would be put and fail. And that's, I think, a really big question that we now have to grapple with, whether the community is prepared to engage in those. Don't forget as well, I mean, the times have completely changed on the way referendums are run. I mean, there is a Machinery of Referendums Act which prohibits expenditure on a referendum question. That had to actually get set aside for the Republic referendum. In most people's in the audience lifetime, the only recent referendum's been the Republic one. It had to be set aside by the Parliament to enable expenditure. Prime Minister Howard said that he would commit to it being any expenditure being equally spent on a yes and no case. Now, that was only set aside for that referendum. If we wanted to spend any money campaigning on a referendum, would have to set that aside. An education campaign is slightly different, and that's been able to be supported. So ask yourself the question, if you're in favour of a campaign to change the constitution for Indigenous Australians, do people think that we should spend 50-50 on a yes and a no case? Do people who are passionately think that there's broad support for yes think that you could have no case, which is what happened in referendums of the past, in some of the successful ones? I don't think the community would accept that. But so there's some really difficult practical questions now about how we run referendums, and I think we've got still some hurdles to get over before a decision's made how we handle it. But there was a couple of other hands going up behind you as we were doing that, I think.
I'm Alistair Lloyd, I'm a student. I had a question about the appointment of High Court judges. In Australia, we don't have democratically elected judges. In fact, there's neither really open or transparent, readily identifiable criteria. And it's been reported that you've potentially suggested you could select from a non-practising lawyer. I was just wondering how serious those words may have been, and maybe if you could illuminate on the issue.
Sure. Look, what I was very sort of public about rattling the cage on was saying, look, we've got 2 appointments coming up. I want the most diverse range of people to be nominated. I want you to look in law schools, I want you to look in firms of solicitors, I want you to look at the bar, I want you to look at courts and see where people are who should be considered and before the government for consideration for these appointments. There was a fair amount of tutting about that and especially because I emphasised that I think diversity is important, whether it's gender balance, whether it's geographic, whether it's different educational experiences. I actually do think that matters. I think it is an absolute necessity that you have brilliant lawyers. That goes without saying when you want to appoint people to the High Court. Whether within that group you can say it's still okay to look for a bit more diversity. I mean, we now have 3 women on the High Court. Never before has that happened. I worked for Justice Gaudron, who was the only woman on the High Court, and there was a sort of a view from a lot of people, oh, well, there's one there now, it's okay. This is not how it should work. None of that means that I will necessarily select someone who doesn't potentially conform with quite traditional standards. But yes, I will consider people. I think the High Court is one of the courts where you potentially could consider academics. I don't think you can say that in all courts because the trial work that's in a lot of courts might make that not possible. As we're going, not everybody RSVP'd, so I haven't acknowledged a whole lot of people I should have, but I mean, Margaret Stone, recently retired federal court judge, one of the few judges taken from the realms of solicitors, widely recognised as the most successful experiment and, example of why you can actually pull people from different areas. So, yes, I'm seriously considering people from different areas, but the bar is very high. The responsibility is very weighty, and the government takes incredibly seriously the way we make this selection. And it's true that there's not a public process. I think people like that there's not an election process for judges. There is a very extensive consultation process with the states, with the profession, with sitting Chief Justices and others, and that process is nearly complete.
There's a question over here. I think we have time for one more. That's the last one. If you could be succinct.
Very. My name's Hugh. I understand, sorry to go back to it, I understand that Mr Williams
That's okay, just tell me where you're from.
I'm from Australian Catholic Uni.
Yep.
I understand that Mr Williams is planning on having another go in relation to the legislation that was passed after his last court case. What will the
He's
government...
got a taste of success.
Yeah, well, I think he thinks he's on a winner. But presumably you've got a contingency. What will the government do if he wins again?
Well, I think there's a few too many ifs there for me to want to answer that in the detail that you would like. Obviously, if he takes the government to court again, we'll defend what we have done, and if the court decides a different principle, then obviously we would have to respond depending on what that decision is. I mean, there are things that are once decided are not fixable. I mean, there are issues that the court can decide which determine something that there isn't a parliamentary process that will cure. And of course that potential is possible, and if that's possible, governments would reconsider whether a particular program would continue, whether it would be done through another avenue, paying money to the states to do something, whether you'd say, okay, that helps our budget surplus this year. I mean, there's lots of different options. You should see the eyes of finance ministers and treasurers occasionally when particularly expensive programs get challenged. It's not all downside for governments. Look, there's too many questions, I think, still there. I guess the point that I wanted to make, because it's something that as students and academics you don't as readily see, and you often only have fairly scant reporting of the detail, which is not a criticism of the media, it's just the truth that the general public won't want necessarily to follow all that detail. It doesn't really, I think, pick up the sort of reach sometimes of a decision, not just on a particular program, but on a whole range of others. And the reason we had such strong and prompt support from the Parliament was not because the opposition particularly wants to help us fix any problems that there are. They'd like us to have as much problem in government as possible. It was helped by the fact that it was originally a program of the previous governments. But actually all of the parliaments said, well, all of the parliamentarians looked through the list of programs. Every one of them had something that was very dear to them that they were surprised was potentially brought into question by this. So if you're the Greens and you're worried about the environmental programs that don't have a legislative base, if you're the opposition and you're worried about a whole lot of business assistance programs that aren't going to necessarily have a legislative base, really, if you're an independent and you've got a whole lot of rural programs that you supported, there's a whole range of different things. So we would obviously just deal with it as each issue comes up. We do have to have contingency planning, which means we have to look at alternative ways to do things. And whilst it probably, obviously by the questions, seems like it's rushed by some people, actually, as I say, you can look at it the other way, which is being ready and prepared and being able to act. You won't always be able to do that, and there will be times where a whole different arrangement has to be negotiated, where you go back to the drawing board for particular things. But people shouldn't imagine that that's just a fun constitutional question to consider. It actually has real programs with real people and real impact that then comes into play. And of course, the courts know that. They've got to interpret the Constitution. They, of course, are aware that it means you might then have to take action to be able to correct it where you can. And the legislation deals with the past. We didn't say, OK, we've got to pass this legislation, let's put another 200 new programs that we've always wanted to do in the legislation. All it did was use a new legislative process for programs that were already identified in the budget papers. So nothing that hadn't been before the Parliament, before Senate committees before. The decision, though, means that when you now make a decision about a new program, of course we will have different considerations that we have to take into account. No question about that. We'll think differently about what should have standalone legislation. We'll think differently about what needs to be supported in a way that might not have been a consideration for governments in the past.
Well, somewhat regretfully, it's my task to bring these proceedings today to a close. I want to do so first by acknowledging the very hard work by the events team at Melbourne Law School to put tonight together. And of course, I want to acknowledge the Attorney-General. It occurred to me there were perhaps two very strong themes emerging from those remarks. One was a very distinctive, even provocative view of the Constitution as dynamic, flexible, ever-changing and never settled. And I think perhaps something of a reminder that all of us as lawyers and certainly as citizens have a role to play in its development or change. And I hope that the Attorney-General might be pleased to know, therefore, in the light of those remarks, that when constitutional law begins next week for our first-year JED students, that we will leap into these questions sort of head first with a very long and very enjoyable, I assure you, discussion of the history of Section 5126 in the courts and current proposals to amend it. And I know the constitutional law teachers here tonight are just really looking forward to engaging with our students on those questions. In addition to that, I know that we're very grateful for your insights into how government responds to major shifts in the status quo, things that we're somewhat shielded from in our position. You've started a series of discussions that will continue well beyond this evening. There is a 2-day conference which many of you will be attending. I know that the discussions will continue there. They will continue in our classrooms. They will continue in the academic common rooms and offices and indeed the cafes of this particular part of Melbourne over the coming weeks and months. And it's because you have brought together a set of remarks on something that's really central to the scholarly and educational mission of Melbourne Law School, and it's been an absolute honour and privilege to have you come and share your thoughts with us today. Thank you.